My name's Jim Holzman. I am Strategic Initiative Specialist for the Bureau of Labor Law Compliance at the Department of Labor and Industry. As you may know, the Department of Labor and Industry covers all aspects of wages and labor standards in the Commonwealth. In addition to the Bureau of Labor Law Compliance, we handle workers' compensation, unemployment compensation, workplace safety, building codes, construction devices, things like that. But tonight we're going to discuss Pennsylvania's labor standards, which does fall within the Bureau of Labor Law Compliance. I'm prepared to discuss 4 topics. We're going to start with wage payment collection law, the Minimum Wage Act, then we may go to general labor standards and the Child Labor Act in Pennsylvania. Differences between the Wage Payment Collection Law and the Minimum Wage Act is the Minimum Wage Act is what you're legally entitled to, what all workers are entitled to, and the Wage Payment and Collection Law is what's promised to you under contract or just a legal promise from your employer. We're going to go through several topics, as you can see from this slide. General information, payments due, wages, deductions, exemptions, employer's duty, unpaid wages, criminal actions and violations for the Wage Payment Collection Law. And under the Minimum Wage Act, general requirements, exemptions and exclusions, allowances, the hours worked requiring wages, travel time, tipped employees, which is a new and discussed topic, home health care workers, on-call time, overtime, the relatively recent 80-20 rule, pay stubs, employer's duty, unpaid wages, criminal pay penalties and violations. Okay, under the Wage Payment Collection Law, it covers wages, and that includes all employees' earnings, anything that's calculated based upon time, piece, commission, or other calculation method, fringe benefits, and wage supplements, which are listed there, non-discretionary bonuses, expense reimbursements, stock options, and vacation pay. It does not include future wages, discretionary bonuses such as holiday bonuses, and payments owed to independent contractors. Pennsylvania's Wage Payment Collection Law governs the payment of all private sector workers in Pennsylvania. There's a similar law, the Federal Fair Labor Standards Act, which covers similar topics, but Pennsylvania can provide greater protections to workers under our law. General rules are employers must pay all wages due to employees on the regularly scheduled paydays that they previously designated, provide sufficient notice if pay rates will change, pay wages in cash or by bank check, payroll accounts or other credit to a financial institution account allowed if the recipient approves it, and notify employees upon hiring of the time and place of employment, their pay rate, and the amount of fringe benefits or wage supplements. Or they can post that information in a conspicuous place at the workplace. Like most labor standards, employees cannot waive these rights by entering a contract. Wage payments are due on certain dates. Generally, the time between the end of a pay period and payday may not exceed the time in an employment contract. The customary time lapse in the trade are 15 days. Overtime pay must be included in the wages for the next pay period. Fringe benefits and wage supplements are due within 10 days after the payments are due to the employer or within 60 days after the employee files a claim. And separated employees are entitled to wages on their next regular payday on which these wages would have been paid. So if an employee is fired or terminated, they're still entitled to their pay. The Wage Payment Collection Law regulations allows deductions that have to be authorized in writing by the employee for their convenience. The department can also approve other deductions authorized in writing if they conform with the intent and purpose of this law. Some examples of unauthorized deductions are employment work rule violations, if property is damaged and the employee did not agree to reimburse for that, or for failure to provide sufficient notice of quitting. Okay, there are some exemptions from the wage payment and collection law. Anything under ERISA. Bankruptcy may prevent actions under this law. The wage payment and collection law does not cover state and local government employees. We cannot initiate a legal action for a wage claim covered by a collective bargaining agreement. Independent contractors, or what they call 1099 employees, it does have to meet a 6-part test. A worker's not an independent contractor because an agreement was signed, or the business designates them as such. It has to meet these 6 bullets which are listed on the PowerPoint slide. Not all 6, but just this is a guide. And it doesn't cover a corporation, but it covers a corporation's workers. Employers have duties. They must give written notice to an employee. If there's a dispute, they must concede whatever's due and say what's disagreed. They must allow the Bureau to inspect all, or my Bureau to inspect all payroll records or other relevant documents at any reasonable time. If the documents are kept in a corporate office or a business office outside the state, they must send it to Pennsylvania within 7 calendar days. They need to provide equipment if it's in a medium that's different. And the Bureau investigators can interrogate any employee about these records or during normal working hours. There can be private actions under the wage payment collection law, or workers can ask the Bureau to take action on their behalf. So employees or groups of employees, labor organizations, or a party can take their own action under that law. Many times actions under the wage payment collection law are taken with other wage laws, or you can file a claim with the Bureau to recover unpaid wages. Parties can seek liquidated damages of the greater of 25% or $500, or wage claims remain unpaid within 60 days of the wage claim, or in other circumstances. If a complaint is made to us, or we also have general authority to inspect records, we can inspect records and interrogate employees. If we get a claim, we must notify the employer of just claims by certified mail. Employers must file a good faith response within 10 days, or may be liable for an additional 10% of the wage claim. Our office can file civil legal action for the unpaid wages, the liquidated damages, and a 10% penalty, but the worker must formally assign their claim to the Bureau for us to do that. We can seek reasonable attorney fees, and the statute of limitations is 3 years. Okay, some of the examples of violations are failure to pay employees the agreed upon wages without notice, failure to pay employees their last paycheck when the employment ends, failure to timely pay employees according to the agreement. A real big one's taking improper wage deductions, and failure to provide access to our department when we're conducting an investigation. Okay, we'll go to the Minimum Wage Act. Okay, Pennsylvania Minimum Wage Act establishes a fixed minimum wage and overtime rate for employees and contains compliance-related duties for employers. The Pennsylvania minimum wage rate is currently $7.25 an hour, which is based on the federal minimum wage rate. So Pennsylvania uses the higher of the Pennsylvania minimum wage or the federal. So if the legislature raised it to $7.50, that would be the minimum wage in Pennsylvania. If the federal government raised it to $10, that would be the minimum wage that we enforce in Pennsylvania. Overtime, employees are entitled to 1.5 times the regular rate of pay. And as we discussed earlier, we can provide more protections to workers than the Federal Fair Labor Standards Act. There's a large list of Pennsylvania minimum wage rate and overtime exclusions. Many of them do not apply to the average worker. Things in agriculture, domestic service, a private home, newspaper delivery, bona fide outside salesman, charitable work, seasonal employment, working in an amusement park, executive, administrative, and professional employees. And there's special rates for learners and students. Okay, wages may include allowances which are reasonable in actual cost of board, lodging, and other facilities. Employers must notify employees of this employment condition. The employee has to accept it upon hiring or classification change. Wages, including food credit plus tips, must equal the current minimum wage. Okay, under the Minimum Wage Act, employees must be paid for all hours worked. That includes any time that the employee has to be on the employer's premises, or at the time they have to be at work, or when they're working. There's no what's called a de minimis exception under Pennsylvania's Minimum Wage Act. Employees must be paid for all time that they work or have to be on the premises. So in a recent case, employees had to go through security screening, which took 8.5 minutes generally per shift. They weren't working, they were waiting to go through security screening. They had to be paid for that time. Rest or meal periods are generally 20 minutes or less, need to be compensated as working time. If they give a work break of, like, let's say 30 minutes for meals, the employee's totally free during that time. They should not be doing work. They can go anywhere they want so long as they come back in time. Travel time is an issue that comes up a lot. There's a lot of rules with that. Generally speaking, home to work travel, so getting your car, going to work, you're not paid for that. Generally speaking, if you report to work and your employer sends you somewhere else or you have to go somewhere else, that time is compensated. Home to work on a special one-day assignment in another city, that's compensated. Going from job site to job site during a day after reporting to work, that time's compensated. Travel away from home community is compensated if it occurs during the employee's regular workday. It's also compensated as time worked during corresponding hours on non-working days. Time spent away and travel away from home outside regular working hours is not compensated work time. And one general rule, if you're doing work during travel time, even if that travel time's typically not compensated, you still have to be compensated for that work. So if you're taking a commuter train from home to work in the morning and you're preparing something for your employer on your laptop or answering emails, that's work time that has to be compensated. Okay, this is relatively new. There were changes in federal law, and the state changed its regulations last summer. Employers can take a tip credit for the employee's base hourly wage if the employee earns at least $135 in tips per month, but the tips in their base wage must equal at least $7.25 per hour. If it's less than $7.25 per hour, it's the employer has to make up the difference. Tips and gratuities paid by credit card or other non-cash payment methods belong to the employee. The employer has to keep their hands off it. Employers cannot deduct credit card or other processing fees from employees' tips. Tip pooling's allowed, and that generally includes employees who are paid a tip credit at minimum wage, which is less than $7.25 per hour without tips. May include individuals in occupations who customarily and regularly receive tips. Managers, supervisors, or employers may not receive tips from a tip pool, but if they participated in service and they want to contribute to the pool, that's perfectly acceptable. They can also receive the tips if they provided the entire service to patrons without assistance. There's something called the 80-20 rule. An employer cannot take a tip credit for an employee if that employee spends over 20% of their weekly working hours in duties do not directly generate tips. Duties that directly generate tips include taking orders, serving food and drinks, preparing alcoholic beverages, bussing tables during meal service, making recommendations and processing payments. Duties that do not generate tips include painting, taking inventory of backroom supplies, ordering supplies, scheduling and cleaning bathrooms. Home health care workers. Home health care workers employed by an agency are not engaged in domestic services and are entitled to overtime wages for any time worked over 40 hours in a week. That was a state Supreme Court case from around 10 to 12 years ago. Okay, on-call time. That's basically where you're away from work or near work, but you have to be on call in case the employer needs you to come back. You can be compensated for that time, or it can just be an employment condition to return on short notice. That's handled on a case-by-case basis. It's basically the amount of liberty that the employee loses during the on-call time if they can't go anywhere or do anything else. Being in contact's generally not compensable. A lot of complaints on an employee's freedom may be compensable. Staying at an employee's place of business during that time generally requires payment. Overtime, unless exempt, employees must receive at least 1.5 times their regular rate of pay for time over a 40-hour work week. Salaried employees who work over 40 hours per week are eligible for overtime if they do not perform executive, administrative, or professional duties and make less than $684 per week or $35,568 per week. The work time is based on a 40-hour work week. Our regulations on that were repealed by the legislature a couple years ago. It's a rather long story. We cannot enforce those exemptions, but the U.S. Department of Labor still has jurisdiction over those exemptions. There's an 880 rule that applies to hospitals or establishments primarily engaged in care of sick, aged, or mentally ill people, and shift trading practices for air carrier employees. Interesting combinations. For the hospitals, employers and employees may agree to calculate overtime on a 14-day, 80-hour work period, but overtime pay is required when an employee works over 8 hours in any workday and over 80 hours in a 14-day period. And again, there's an exemption for shift trading practices for air carrier employees. Overtime is exempt for air carrier employees who work over 40 hours in a work week under a voluntary agreement among employees to trade schedule work hours or under a collective bargaining agreement covering required work hours and compensation. Employers can require overtime even if the employee objects to it, so long as they pay it. The one exception is the Prohibition of Excessive Overtime and Healthcare Act, which sets standards for healthcare workers working at public and non-public healthcare facilities. We may get to that a little later. There's certain requirements that they must comply with, or the healthcare worker can refuse overtime. Like a lot of other things, that should be employees may not waive their right to receive overtime pay. Use of compensatory time in place of overtime pay is illegal. Number of employees at a facility or workplace does not affect whether overtime is paid or not. It has to be paid. And as we discussed earlier, it must be included in the wages for the next pay period under the Wage Payment and Collection Law. Like the Wage Payment and Collection Law, employers have a lot of duties. They must keep accurate records for each employee of their names, their occupations, hours worked in that occupation, the hours worked daily and weekly, total work week wages including overtime, allowances, wages paid for each paid period, payment dates and pay period covered, total deductions, and employers must keep these records for at least 3 years. Labor and Industry has a workplace poster. It's on our website. Employers must post it in a conspicuous place. Usually see them in break rooms. Like the Wage Payment and Collection Law, we can file a civil legal action for unpaid wages if an employee assigns their claim to us. Employer pays all costs and reasonable legal fees if found liable. And there's a contract does not excuse payment of required wages, minimum wages, and overtime. We can file criminal action. Each week the wages are due as a separate violation. Corporate officials can be prosecuted. And again, an agreement's not a legal defense. It's also a criminal offense to retaliate against a worker, and if they violate other parts of the Minimum Wage Act. And our Bureau has 5 regional offices. We're centered in Harrisburg in the Labor and Industry Building, which is there, but we also have a regional office there. So anyone with a complaint or question, you can contact any of these offices. And we also have a website for our laws. You can get copies of the laws, the regulations, some general information, complaint forms. You can file a complaint online. There's mandatory workplace posters. Okay, so we collected some of the 5 of the laws. So I'll briefly go over the Construction Workplace Misclassification Act. As I discussed earlier, there's for healthcare workers, there's a Prohibition of Excessive Overtime and Healthcare Act, Personnel File Inspection Act, Medical Fee Act, and the Equal Pay Act. There was an issue that became apparent like a decade ago where, especially on construction sites, contractors were misclassifying employees as independent contractors, even though they were acting as their employer, the employers had control over them. But the legislature passed a special law governing construction work. So this law, which the nickname is Act 72, workers are independent contractors if certain criteria is met. There must be a written contract to perform construction with the business or person. The worker is free from control or direction over the performance of these services, and that workers customarily engaged in an independently established trade occupation, profession, or business. And that last prong, the third prong, there's a 6-part test for that, and that's basically that the worker possesses their own tools. By being an independent contractor, they realize their profit or suffer a loss. They must have a proprietary interest in the business. They must have a business location separate from the business or person for whom the biz services are being performed. Independently perform the same services for another person, or available to perform those services for another person. And they must have liability insurance of at least $50,000 during the term of the contract. Penalties can be imposed against a company, its officers, or an agent for violating this law, or violating Pennsylvania's workers or unemployment compensation laws. The agency, after an administrative hearing, can impose civil penalties of up to $1,000 for the first violation and up to $2,500 for each subsequent violation. And employers can appeal those decisions to the state's Commonwealth Court. The agency also has the power to refer intentional or negligent violations to the Office of Attorney General for criminal prosecution. And we can also seek a stop work order from a court of competent jurisdiction for intentional violations. That means a court can order the construction to stop. Okay, this is Act 102, came about in 2009. Essentially, the legislature found or had a concern that fatigued workers can make healthcare mistakes, get injured at work because of fatigue, or suffer health problems. So they enacted the Prohibition of Excessive Overtime in Healthcare Act, otherwise known as Act 102. And healthcare facilities may not require an employee to work longer than an agreed to, predetermined, and regularly scheduled work shift. They cannot retaliate against workers who refuse to accept or work overtime. Our Bureau enforces Act 102. We can impose fines from $100 to $1,000 per violation. The Bureau can, the department can order a healthcare facility to take corrective actions to assure that these violations don't occur again. And this law does not address overtime wages. That's addressed under Pennsylvania's Minimum Wage Act. And there is a definition of an employee. Those are individuals employed by a healthcare facility, which can be operated by the state, local government, private entity. The employee must be involved in direct patient care activities or clinical care services who receive an hourly wage, and classified as a non-supervisory employee for collective bargaining purposes. This law also protects individuals employed through a personnel agency that contracts with a healthcare facility to provide personnel. Healthcare facilities provide clinically related health services, and they can be operated by the public. They can be private, profit, nonprofit. Generally includes most any hospital, rehabilitation hospital, hospice, ambulatory surgical facility, long-term care, nursing facility, cancer treatment center, inpatient drug and alcohol treatment facilities, state-operated facilities which provide clinically related health services, and facilities operated by the state's Department of Human Services. This law does not protect workers who are doctors, physician assistants, or dentists. Support personnel like clerical, maintenance, food service, and individuals who are not employed by a healthcare facility. It does not cover private doctors' offices, religious-related facilities that provide treatment solely on the basis of prayer or spiritual means, and a facility conducted by a religious organization for providing healthcare services. EMTs are usually not covered unless they're employed by a healthcare facility. It would cover home healthcare workers if they work for a facility that is a healthcare facility under the law, and it would cover pharmacists who are employed by a healthcare facility engaged in direct patient care activities or clinical care services who receive an hourly wage or are classified as a non-supervisory employee for collective bargaining purposes. Mandatory overtime is allowed in an unforeseeable emergent circumstance. So it's basically an emergency that was unforeseeable. Those are declared national, state, or municipal emergency. Any highly unusual or extraordinary event, which is unpredictable or unavoidable, such as an act of terrorism, a natural disaster, as we experienced recently, a widespread disease outbreak. Unexpected absences discovered at or before the commencement of a scheduled shift, so like weather that was not predicted or planned or expected, that could possibly be one. It's not a posted hole in the schedule, chronic short staffing, foreseeable or expected absences. So facilities should be aware that, for example, Super Bowl Monday, there may be a lot of call-ins, so they should be prepared for that. If they do mandate an employee to work for an unforeseeable emergent circumstance, they have to provide them with up to 1 hour to arrange for the care of the employer's minor child or elderly or family member with a disability. Provide the employee with at least 10 consecutive hours of off-duty time. Immediately after that, mandatory overtime. But an employee may voluntarily waive that time. We enforce Act 102. We can investigate alleged violations based upon an employee's complaint or the department's own initiative. Employees may file a written complaint with the Bureau within 60 days of the alleged violation, and we'll review and begin an investigation within 60 days, and we notify the complainant and healthcare facility in writing after its investigation if there's no finding of a violation. Okay, employees in Pennsylvania also have the right to review the personnel files under certain circumstances under the Personnel File Inspection Act. And employees can request that they or their agents can inspect their personnel files to determine their own qualifications for employment, promotion, additional compensation, termination, or disciplinary action. The one rub is that an employee is a person currently employed, laid off with reemployment rights or on leave of absence. What's considered as part of the personnel file is applications, wage or salary information, commendations, warnings or discipline, pay withholding or deductions, fringe benefits, leave records, employment history, performance evaluation. And that has to be authored by an individual who's under the employer's supervision, direction, or control. Generally compensated people who evaluated the employees. Oh, sorry. What it does not include, and employees do not have access to this information, employee records relating to the investigation of a possible criminal offense, letters of reference, documents which are being developed or prepared for use in civil, criminal, or grievance procedures, medical records, future operation plans by the employer, and information available to the employee under the Fair Credit Reporting Act. If access is granted, the employer shall make personnel files available during regular business hours at the office where these records are usually and ordinarily kept. Inspections may be limited to once per year except for reasonable cause, Employees may authorize an agent to inspect their file if they provide a signed authorization. Sufficient time must be provided for the file inspection. The time's appropriate to the size of the file. Employer or their agent can take notes. Employer can request that the inspection take place on their own free time or their agent's free time. Employer can require an employee to complete an inspection access form and provide the identity of their agent to assure that the file is not disclosed to unauthorized individuals. Employers may prevent photocopying of file contents. They can prevent employees, their agents, from taking the file or its contents. They can take steps to protect personnel files from loss, damage, or alteration. They can require inspection in front of an employee to assure that nothing happens to the file. But employers can't allow, in many cases, employers, when a request is made, will just photocopy the file and send it to the employee. So they do have the option to allow photocopying, release contents, inspect at other locations. So it's worth it for the employee to at least ask. Even if the law does not provide these rights, many times employers will just provide them. There's two ways to get access to your files. You can ask the Bureau of Labor Law Compliance, and we have a form on our website to provide for access, and we can conduct a hearing if a timely request is made by a current employee for access. We rule on those requests. We can order that the employer accept a counter statement to be placed in the file. Excuse me. We can take remedial action if warranted under other laws, but we cannot order employers to correct errors, and the Bureau cannot inspect the personnel file itself. Now, employees also have other rights unrelated to the Personnel File Inspection Act. So if an employee files a wrongful discharge lawsuit, they can seek discovery and gain access to their files that way. Many employers have grievance procedures that grant rights to files. Okay, this law came up a little bit during the recent COVID, I'd like to say past, but during the COVID crisis. The law covers when employees do not have to pay for medical examinations. Non-government employers may not require an employee or job applicant to pay the cost of a medical examination or furnishing of medical records required as a medical condition. The employee or applicant to be covered under this law must work for an employer at least one work week. The law does not govern situations where medical examination is legally required as an employment condition. And this law does cover situations where employers require a doctor's note or excuse to avoid discipline or obtain sick leave benefits. Our Bureau enforces it. It's a summary offense with modest fines. Pennsylvania has an equal pay law. We actually had our equal pay law a few years before the federal. Government and private employers may not engage in gender discrimination by paying wages to any employee below the wage rate paid to employees of another gender for work under equal conditions requiring skills. This law protects individuals who would be considered executive, administrative, professional, and outside sales employees. It does not cover employees who receive all the protections under the Minimum Wage Act. Unequal wages are not prohibited when based on seniority, training, quantity or quality of production, or merit increase system that does not discriminate because of gender. An interesting aspect is employers cannot lower the wages of other employees to equal the unequal or the discriminatory wages. Agreements are not a legal defense, and employers must post a poster or abstract. Employers have record requirements, very similar to what's required under the Minimum Wage Act. They must contain each employee's name and address, the wage rate. They must keep records for at least 1 year, but longer if a relevant legal action is pending. But keep in mind, they must keep similar records under the Minimum Wage Act for at least 3 years. Employers must provide Bureau access to records when requested at its regular business during normal business hours. The Bureau of Labor Law Compliance enforces the law. We can inspect wage records and seek employer summaries, can take legal action to collect for unpaid wages if claim is assigned by the employee. Employees are on their own behalf or on behalf of other employees can take civil action within 2 years. The Bureau may file civil action for employee and other employees within 2 years of claim is assigned, and the court may award unpaid wages, liquidated damages for an equal amount, costs, and attorney fees. And there's also criminal penalties for violations. Okay. Pennsylvania, like most states, has a Child Labor Act that's intended to protect children so they're not harmed at the workplace, they're not exhausted, and they can continue their education without interruption. The federal government also has, under their Fair Labor Standards Act, protections for children engaged in work. Generally, the Pennsylvania law is more stringent than the federal law. And like many labor standards, whatever law is more stringent covers a particular activity. And a couple items, the federal government's more stringent than Pennsylvania's. Pennsylvania has a long history of providing workers' rights. Until 2013, we had a law that was passed in 1915, signed by that governor. It was a bit outdated. It was updated through the years. It covered television in, I think, 1980s with amendments and movies, but it needed a big change. So it was rewritten, and a new law took effect in January 2013. It covers age restrictions, work permits, employer duties, work hour limitations, prohibited occupations. There's exceptions for sports attendance services. It covers children and entertainment, voluntary emergence services, and has provisions on enforcement, violations, and penalties. It does not cover agriculture work that's not governed by the Federal Fair Labor Standards Act, domestic services in or about the parents' or guardian's home, babysitting, minor chores about the house, and doing things like shoveling snow on a snow day, cutting grass for the neighbors, things that are done on a casual or infrequent basis. Generally speaking, a minor must be at least 14 years old to work in the state. There are exceptions for newspaper delivery, which are here. Minors from 14 through 17 must get a work permit from their local school district. Issuing officers at the school district have a lot of power under the Act. They can refuse to issue and they can revoke a work permit because of inadequate academic achievement. but they must cooperate with enforcement officers such as our department, the police. To get a work permit, the new law changed it a little bit. The minors must submit proof of age, appear for inspection by an issuing officer, and since COVID, that's been allowed to be a virtual appearance, and keep up their grades. For performances, though, labor industry issues the entertainment permits. If the minor's under 16, they must obtain written verification from their parents acknowledging that they understand their duties and employment hours and their hours, and grant permission to work, and that must be kept by the employer. Within 5 days of commencing employment, the employer must notify the school district in writing of their duties, hours, their age, and the permit number, and within 5 days of their last day of work, they must notify the school district. And the department has a mandatory poster on it. You can get on our website that must be displayed. During the time a minor is employed, employers must keep these records, the work permit, the verified permission statement, the 5-day letter announcing the employment, a list of all minors employed at the workplace, their schedules, required records under the Pennsylvania Minimum Wage Act, and they must provide access to the Bureau and other enforcement agencies to those records. Minors are the one group of workers in Pennsylvania that are entitled to a 30-minute break after working 5 consecutive hours. They cannot work for more than 6 consecutive days. There's hours addressing a regular school week, which is Monday through Friday. But with entertainment, because of scheduling and time to shoot movies, those hours can be modified. There's different sets of hours based on age for 16 and 17-year-olds. There's hours set for the school year, which are up there. There's slightly different hours for school vacations. They can work up to 48 hours a week, but a minor can object to any time after 44 hours. School vacation includes Saturdays and Sundays. There's special hour requirements for camp counselors, counselors in training, junior counselors. The one exception is that minors who graduated high school, so if you have a 17-year-old who graduated high school, or they're excused from attendance under the public school code, the hour restrictions do not apply, but they must comply with all other requirements of the Act with working papers and staying away from prohibited occupations. 14 and 15-year-olds have less generous hours, as I listed here. There's differences for school time and vacation time. There's also some exceptions, some limited exceptions, which I listed on the right. The law does prohibit certain occupations and use of equipment. Some prohibitions apply to all minors under 18. Some just apply to 14 and 15-year-olds. Also, the Pennsylvania law incorporates any prohibitions under federal law. The federal government has its own list of prohibited occupations that are also prohibited in Pennsylvania under our law. We have a list on our website that you can download or read that lists everything that's prohibited or hazardous. So in addition to anything hazardous under the Fair Labor Standards Act, we have restrictions with our entertainment permits, certain occupations involving serving on a boat or vessel, railroads, and certain manufacturing activities. Those are restricted from all minors. Minors under 16 cannot engage in youth peddling. Those are groups of children who were living in one place and they were selling magazine subscriptions. They cannot strip or sort tobacco, work on a scaffold, or work in a tunnel. Minors at least 16 may work in part of the establishment where alcohol is not served. A minor who's at least 16 may serve food, clear tables, and engage in related duties in a hotel, club, or restaurant that has a PLCB Sunday liquor license, but they cannot dispense or serve alcoholic beverages. And a copy of the PLCB Sunday sales license must be submitted to the school district. Minors under 16 may work at continuing care, retirement, community, ski resort, bowling alley, other listed places here. If they're working in a place where, in an area where alcohol is not located or served, and they're not permitted to handle alcohol. Students receiving instruction in a performing art to perform an exhibition of this is not where they're not compensated and they're under proper supervision can come and do a short performance in a bar or restaurant. So on certain holidays, a group of kids come in, do an ethnic dance. There's adults with them. They do the dance, get applause, and leave. That's permissible. Sport attendance services is allowed. It's basically what they used to call a ball and bat, boy or girl. If they meet these requirements, they're exempt from hour and time restrictions. Okay, as we discussed earlier, labor and industry, like many states, especially like California and New York, and I think Illinois, issues entertainment permits. So minors under 18 who engage in a performance in Pennsylvania need a special permit issued by the department. Performance is rather broad. It's movies, radio, television, any broadcast medium, so even like the internet, so long as someone's being paid. It includes reality or documentary programming. They need permit. They have to play a substantial role, so if they're just walking by or something in a reality television show, it likely does not cover them. Another special permit is needed for professional acrobatic performances. Pennsylvania's Child Labor Act also covers or allows minors to engage in voluntary emergency service organizations. They have to be at least 14. They can perform certain activities for these organizations. All minors under 18 for these agencies cannot do certain items such as operating the vehicles, ladders, aerial platforms or jacks, using rubber gloves and equipment, operating a fire pump at the fire, engaging in forest fighting, or entering a burning structure under any circumstances. There is a limited exception for minors who are at least 17. They can enter a burning structure for training only. They need permission from the fire chief and their parent or guardian. It must be under the supervision of a credentialed Pennsylvania State Fire Academy instructor. But that only applies to 17-year-olds under that limited circumstance. No minor can enter a burning structure in a live fire. 14-year-olds, 15-year-olds have limited activities they can engage in. but they cannot do firefighting, operate high-pressure hoses, extend ladders during training exercises. Okay, the Bureau of Labor Law Compliance is one of several agencies that can enforce the child labor law. We're probably the major one. We can issue investigative subpoenas. We can enter and inspect premises at any reasonable time, including locations where performances are being filmed or recorded. We can interview workers, inspect and obtain copies of any records, documents, or information in any medium, and we can prosecute alleged violations. Other enforcement officers include law enforcement, the school district's issuing officer, an attendance officer, and their chief school administrator. Enforcement officers like the Bureau do have the power that the employer furnish proof of age of any minor within 10 days and demand that the employer cease permitting the minor to work or employing them. Failure to comply with either of these demands is a violation of the Child Labor Act. Additionally, other violations include violating requirements on record keeping, recording, allowing access, interfering with enforcement officers' duties, compelling or allowing a minor to violate the Child Labor Act, falsification of records. The department can impose administrative penalties by holding and employers have a right to an administrative hearing. It's up to $5,000 per violation. The hearing's before a neutral hearing examiner with a right of appeal. We can seek the imposition of criminal penalties. And Pennsylvania's workers' compensation law has a provision that if there's a violation of the Child Labor Act, the minor is awarded 150% of the benefits for being injured. So if a minor is working without a work permit and they're injured, they're entitled to 150% of benefits. And like our other laws, there's information on our website. As I said, during our other laws, we usually have abstracts of the law or posters, complaint forms, which can usually be submitted online, copies of the act and the regulations. Some laws have frequently, like the Wage Payment Collection Law, Minimum Wage Act has frequently asked questions. Act 102 also has frequently asked questions to help workers and employers trying to comply with the law. And our website has, as I said before, a lot of information, frequently asked questions, summaries that can assist you with understanding the laws and compliance, and complaints are available also online. The 5 offices which I have on our PowerPoints our Bureau personnel at those offices will also be glad to help you out.